Hello, and welcome to the DC Bar Pro Bono Center's webinar, Mandating COVID-19 Vaccination for Workers, What Employers Should Consider. I'm Christine Kulumani, staff attorney with the DC Bar Pro Bono Center nonprofit and small business legal assistance programs. First, thank you to my colleague, Lauren Paley, who has done so much behind the scenes work to make today's webinar possible. Also, a tremendous thank you to Arent, particularly our presenter, Associate Arent Alexandra Romero. Also, a huge thank you to the Washington Metropolitan Area District Office of the U.S. Small Business Administration for allowing Economic Development Specialist Nick Rajpara to join us today. Before we get started, I'd like to go over a couple of logistics for the webinar. First, for those of you joining us live, this webinar will be recorded. To access the recording, please complete the post-webinar survey that we will email to you. In addition, you have access to the presentation slides right now in your GoToWebinar control panel under Handouts. If you have questions as we go, please send them through the GoToWebinar control panel questions box. We'll get to as many as we can during today's programs, as well as address questions that we are able that you sent in ahead of time. And now that we're done with the mechanics, a reminder of what we're here for. COVID-19 has changed the world as we know it, causing millions of deaths and devastating economic hardship globally. Currently, the US has approved emergency use authorization for 3 COVID vaccines. As access to these vaccines grow and employers update their safe opening and operations plans, nonprofits and small businesses are considering requiring workers to receive vaccinations. Today, we'll explore the legalities and complexities of doing this, as well as other steps that employers can take. And for employers to even consider mandating vaccines and other steps to take, they first need to consider if they have sufficient funds to pay employees, cover rent, and other day-to-day expenses to operate their business or nonprofit. And with that, Nick from the Small Business Administration will briefly talk about the Paycheck Protection Program and financial relief programs for organizations. Thanks, Nick.
Thank you. Well, thank you. Thank you for that kind introduction, Christine. I want to express to everyone on this webinar what an absolute pleasure it is to be here on this webinar hosted by the DC Bar's Pro Bono Center. I absolutely love the very important work that they do and love working with them. So I did want to mention that. Now, when Christine asked me to come speak to you about the Paycheck Protection Program, the first draw, second draw, she said, well, please speak to them. The deadline would be very close to the deadline. And I so desperately wanted to announce to everyone on this webinar that the deadline has been extended. Unfortunately, it is not. There is pending legislation out there in the Senate and the House to extend the deadline. But until that legislation is signed into law by the president's pen, it is speculation in terms of as far as SBA is concerned. So the current deadline as of 12:04 p.m. on March 24th, as I speak to you, is still March the 31st. Having said that, you do have time to apply for your first draw and your second draw. And I could speak to that from a personal anecdote. My sister, who is a designer in LA, is not very savvy on government programs, government assistance programs. In just a family conversation, just over the phone, I was just talking about what I was doing at work and what was keeping me busy. And I started talking about the Paycheck Protection Program, and a light bulb went off in her head. She said, oh my God, I could apply for that. I don't know why I'd never applied for that before. She went on just 2 days ago, applied, and got approved. Having said that, if you do plan to apply for the first draw or the second draw, do it as soon as you can, sooner than later, because even if you're approved, your lenders do require supporting documentation. We always encourage people to start with a lender that they already have a business relationship with. So whoever your small business relationship is, whatever small business relation lender you have, start with them. If you cannot access a PPP loan through them, you could go to our website. And I'm actually, Christine, if you could please click through to the next slide. Yes, thank you. You can go to our website. This is a great landing page for all the pandemic assistance programs, not just PPP. But if you click around here, you would find a lender match option, which would help you find another PPP lender if the PPP loans are not available through your current lender. Now, that is just for PPP, the first draw and the second draw. The deadline is still March the 31st. The second draw, if you are planning to apply for that, again, do that sooner than later. It is a little bit more rigorous in terms of documentation because the loan requirements, qualifications to be eligible for the second draw are a little bit more rigorous. You had to show a revenue decline in any given quarter in 2020, comparable to that same quarter in 2019. The decline has to be, of revenues has to be at least 25% or greater. You had to be able to demonstrate that through income statements. You had to also have your first PPP loan dispersed and used. And also the business size standards are a little smaller, 300 employees as opposed to 500 employees for the first draw. The loan cap is smaller, 2 million loan cap as opposed to 10 million for the first draw. So just some things to keep in mind as far as PPP is concerned. Now, if you scroll, I'm sorry. Yeah. If you see the other programs that are also on this landing page are very important that your business could possibly take advantage of. The Economic Injury Disaster Loan, EIDL, it has been updated. The program was extended for another year in the Economic Aid Act that was passed on December 27th. So the deadline to apply is now the end of this year. The deferment period has been extended from 12 months to 24 months. So if you originated your EIDL loan in 2020, you had an automatic deferment of 1 year. Now that's 2 years, and that's on your principal and interest. If you are going to be taking out an EIDL loan this year, the deferment is 18 months. It's been extended 18 months. So that's an important development, favorable to your small business. And for those of you who don't know, the big difference between the EIDL and PPP is PPP is originated, the loan is made, originated, and forgiven by a third-party lender. The EIDL loan is a direct loan from the Small Business Administration to your business. Now, there are other new programs that have been created from new legislation, such as a shuttered venues operating grant. These are for venue operators. This is a new program that was created out of the Economic Aid Act. The program is slated to go live on April the 8th. So if you're a shuttered venue, you could apply directly through a portal that you could find from this page. I did click on that portal. The landing page, the splash page for the shuttered venues operators grant was supposed to go live a couple of days ago. I did click on it this morning, and it is still buggy. It was down this morning. But anyway, the program is slated to start taking applications, grant applications. These are on April the 8th. Now, you probably heard of a restaurant revitalization grant, which is created out of the American Rescue Plan. The guidance is still being written for that particular program, but any program, a new program offered by the SBA, Small Business Pandemic Assistance Program, could be found on this landing page. So if you have not done so, please bookmark this page, save it in your favorites, refer to it. You will find the latest and greatest information on all the pandemic assistance programs for small business on this landing page. And this is not just information, but also access to the programs, the applications, and what have you.
Nick, before we move on to Alexandra and mandatory COVID vaccines, are there any additional resources that you think are helpful to share to the small businesses and nonprofits that are listening?
Yes, my next two slides, and I could just summarize that because I know we got to get to Alexandra and a wonderful presentation. The Department of Treasury puts out a great slide for all pandemic assistance programs for small business. You know, these are some things that the programs that SBA is not tasked with, such as the employee retention tax credit. You could find information on that program on the Treasury website. And it's also important to know how these programs play with SBA programs. I'm not going to go into details on that, but you could read up on those additional pandemic assistance programs outside the SBA on the Treasury website. And this particular page is an entire federal response to the COVID-19, what each agency is doing, their respective programs for the coronavirus. I was surprised to see certain agencies have programs such as the Department of Homeland Security have a program on coronavirus response. So this is a really important page, you know, for your business, and maybe for your family, your community, which you can refer to see what the federal government's doing in response to the COVID-19 pandemic.
Wonderful. Thank you, Nick. And
absolutely.
With that, we will turn it over to Alexandra to dive into the main related feature, mandatory vaccines.
Great. Thank you, Christine. Thank you, Nick. And thank you, all of you. It's a pleasure to be here today. As Christine said, we are going to be talking about mandating the COVID-19 vaccine in the workplace. And as I know all of you know, the workplace looks very different now than it did a year ago before the start of the COVID-19 pandemic. And as the rollout of the vaccine continues to pick up pace, employers are faced with a variety of questions about whether and to what extent they should implement a vaccination program in their workplaces, and specifically whether they should mandate that employees get the vaccine as a condition of returning to work. Now, some employers might be surprised to learn that although there are many novel aspects of this pandemic, mandatory vaccinations are not really a novel employment issue. Some employers have been mandating that employees get certain vaccines for a while now, particularly in the healthcare sector, where it's relatively common that employees, and particularly in patient-facing roles, are required to get the flu vaccine, for example. But as with so many aspects of this pandemic, there are some unique considerations for employers to think through with respect to the COVID-19 vaccine and implementing the vaccine into their safe work practices. Okay, so there are several federal employment statutes that are relevant to vaccinations in the employment context that we're going to be talking about today. First, the Americans with Disabilities Act prohibits employers with 15 or more employees from discriminating against people because they have a disability. And Section 504 of the Rehabilitation Act includes a similar prohibition that applies to any employer that receives federal funding. And these requirements limit the ability of employers to conduct medical examinations or ask questions that might elicit information about an employee's health status or about the existence of any type of a disability that they may have. Third, the Genetic Information Non-Discrimination Act prohibits covered employers from acquiring employee genetic information and using that information to make various employment decisions. Now, prior to the COVID-19 pandemic, asking health-related questions, conducting or requiring medical examinations or medical procedures was prohibited under these statutes unless the employer could show that they were job-related and consistent with some sort of a business necessity. However, the EEOC, the agency that enforces these laws, issued some new and updated guidance in December of 2020, discussing how these statutes may apply in the context of the COVID-19 pandemic, and specifically how they might apply to employment-related COVID-19 vaccination requirements. So in December of 2020, the EEOC issued updated guidance. They've been issuing a number of guidance documents throughout the pandemic, and this new guidance addressed COVID-19 vaccinations in the wake of the FDA having authorized the Pfizer, BioNTech, and Moderna vaccines through their emergency use authorization process. And since then, the FDA has also issued what's called an EUA for the Johnson & Johnson COVID-19 vaccine, which is a single-dose vaccine in comparison to a two-dose process for the Pfizer and Moderna vaccines. So this guidance followed up and expanded on earlier rounds of guidance, talking generally about how employers can navigate COVID-19 related health and safety risks while also complying with applicable workplace anti-discrimination laws at the federal level. And of course, there are many state and local anti-discrimination requirements that are very similar to those that exist at the federal level. So these statutes are listed below, the topics that the guidance primarily addresses. And in addition to the ones we discussed on the prior slide, the guidance also addresses considerations that may be relevant to ensuring compliance with Title VII of the Civil Rights Act, which prohibits discrimination on the basis of race and national origin, religion, other protected characteristics. Great. So the big question that we are talking about today, what did the EEOC say as to whether or not employers can require employees to get a COVID-19 vaccine? So reading the guidance, the answer to that question is that the EEOC has said generally yes. Employers are permitted to require employees to get a COVID-19 vaccination with a couple of important caveats. There may be circumstances where employers have to provide accommodations to employees who decline the vaccine for disability-related reasons, and as we'll talk about in a second, also employees who object to getting the vaccine for religious reasons. So the ADA, in addition to prohibiting discrimination on the basis of disability, imposes an affirmative obligation on employers to provide reasonable accommodations to employees who are qualified and who have a disability, unless providing the accommodation would result in an undue hardship to the organization. Now, there's an exception to that requirement. Employers do not have to accommodate a disability that an employee may have if the individual would pose what's referred to as a direct threat to the health or safety of individuals in the workplace. And now in prior rounds of guidance and reiterated in this most recent guidance document, the EEOC has been pretty clear that COVID-19 poses a direct threat to the health or safety of individuals in the workplace. So this is a scenario where there may be times when an employer is not obligated to provide an accommodation, and we're going to discuss, the considerations that go into making that determination in some detail. So one other important thing to remember is that if an employer is imposing a mandatory vaccination requirement to ensure the safety of their workplace, and that program has a tendency to screen out employees with a disability, then there is a little bit of a heightened burden for employers to meet. They have to show that unvaccinated employees, if they were allowed to return to the workplace, would pose a direct threat due to a significant risk of substantial harm to the health or safety of the individual or to others that can't be eliminated or reduced by providing a reasonable accommodation. And so here in this context, because one of the reasons why employees may be reluctant or even unable to get a vaccination has to do with certain medical conditions that may be contraindicated to the vaccine and may make it difficult for them to obtain the vaccine, because that is likely to be a common reason why employees are reluctant to comply with any type of a vaccination requirement. This very well could be a circumstance where employers have to consider the overall impact of the program and the way that it may have a disproportionate impact on employees with disabilities. So in determining whether or not a direct threat exists, if an employer were to allow an unvaccinated employee to return to the workplace, there are four primary factors that they should consider. First, the duration of the risk of allowing the employee back into the workplace, the nature and severity of the potential harm that could result if an unvaccinated employee returns to work, the likelihood that that harm will occur, and the imminence of the potential harm. So looking first at the first factor, the duration of the risk, it very well may be that if you have an employee who is reluctant or unable to obtain the vaccine, it could end up being that this is a short-term problem as the vaccination process continues, as supply increases and access to the vaccine continues to move more quickly over the coming months. We could be facing a scenario down the line where the vaccine is really available to anybody who wants it. And if you have a high level of vaccine uptake within your employee population, it could be that, allowing someone who's unable to get the vaccine to, for example, work remotely for a short period of time may be a way to address that risk, because in the coming months, the rest of your employee population will have been able to obtain the vaccine and will be protected. With respect to the second factor, the nature and severity of the potential harm, as we all know and as we've seen, the severity of the harm of contracting COVID-19 can in many cases be very severe. So that's a consideration that will weigh very heavily as employers are considering whether or not to impose any kind of a mandatory vaccine program. The likelihood of the potential harm, when evaluating this factor, it's important to consider other ways that you could mitigate any potential risk. And we'll talk about that in a few minutes. And then the imminence of the potential harm. How likely is it that this threat could present itself very quickly if an employee returns to the workplace? That could depend on, if you have an employee who interacts regularly with the general public, then the imminence of the harm of transmitting or contracting COVID-19 could be pretty significant. But at the end of the day, the question that employers have to ask is, will an unvaccinated employee expose others, whether it's other employees, customers, or any other third party who they interact with in the course of their work? Will they expose others to the virus? And if that is a possibility, then employers have to ask, is there any way to provide a reasonable accommodation that would reduce that risk to a level that there's no direct threat to others? So what types of reasonable accommodations may be available if an employer has an employee who's unable to obtain the vaccine that would reduce the risk of allowing them to come into the workplace even though they have remained unvaccinated? Now, all of these potential accommodations are things that should look very familiar to people. They're the steps that employers have been taking throughout the course of the pandemic to manage risk in their workplace prior to the vaccine becoming available. Social distancing, making sure that you're separating employee workstations in the workplace, requiring that employees wear masks, providing employees with masks, making them available throughout the workplace. Reconfiguring workspaces, whether it's putting up some type of a plastic barrier, making sure that cubicles are more spaced out than they were previously, requiring employees with offices to stay in those offices with the door closed, things along those lines. Eliminating common spaces, such as closing break rooms, lunch rooms, limiting access to conference spaces, and other measures to avoid places where employees can congregate in large numbers. Increasing ventilation. This is a topic that employers have been focused on. Many employers who work in office spaces have been working with their landlords to figure out what options may be available or modifications to HVAC systems to ensure greater ventilation and reduce the risk of airborne transmission of the virus. And then reducing office capacity. If employers have been allowing employees to come back into the workplace, so far many have done so in fewer numbers. They've set caps at certain percentages of the employee population are allowed to be in the office at any given point in time. And if your workplace is anything like mine, and you've been to the office throughout the pandemic at any point, many employers have done things like putting up signs to indicate that hallways have a single flow of traffic, or putting little dots on the floor of elevators indicating where people are supposed to stand to ensure that there's as much distance as possible. So, when you're looking at possible accommodations for employees who may not be able to get the vaccine, a lot of the things that you may be considering to reduce the risk are probably things that you've already been doing since the pandemic started. So, On that topic, OSHA, the Occupational Safety and Health Administration, has also been issuing guidance throughout the pandemic about what employers should be doing to ensure that their workplaces are as safe as possible. And they issued another round of guidance recently on January 29th, 2021, that lays out some additional procedures and recommendations for safe work practices that employers should consider adopting. And they also addressed what employers should or can do with respect to the COVID-19 vaccine. And the guidance, although it doesn't say that employers must mandate that employees obtain the vaccine before returning to the workplace, they do strongly encourage it. And they say that if employers are able to, they should consider providing the vaccine at no cost to employees as a method of encouraging employees to get the vaccine. But importantly, the guidance does say that even with any type of a vaccination program, whether it's mandatory or purely voluntary, employers still should not be making distinctions between vaccinated employees and unvaccinated employees when it comes to their work practices, meaning that for now, at least, everyone in the workplace should continue following the protective measures that we just discussed, even if and even when employees begin to be vaccinated in large numbers. And so those measures include all the things we just talked about, social distancing, face coverings in particular, and other steps that have been included in prior rounds of guidance. What happens if there is some type of a mandatory vaccine program that an employer has put in place? There are employees who are unable to get the vaccine, and there just really is not any type of a reasonable accommodation that employers could pursue that would allow the employee who's unvaccinated to return to the workplace at a low enough level of risk where you're really not posing a safety hazard to other employees. In your typical office environment, it may be that this situation arises pretty rarely. As we've seen, there are a lot of alternatives that employers have been utilizing to minimize this type of risk, for example, allowing telework. But there are some workplaces where there very well may be a level of risk that's difficult to eliminate through other measures. In these types of situations, think, in manufacturing facilities, for example, it simply may not be possible to allow for adequate levels of social distancing. Or if you have a workplace where employees are regularly interacting with customers or otherwise are out in the community interacting with the general public on a consistent basis. So under those circumstances, if you have an employee who is unable to be vaccinated and there are no other reasonable accommodations, what can the employer do? Is the employer allowed to simply terminate the employee because they can't perform the work in a safe way? Well, it depends. And in order to go through that decision-making process, first, what employers want to do is make sure that they've determined whether there are any other rights that may be available to the employee under applicable federal, state, or local EEO laws or any other type of legal protection. So, for example, if you have an employee who has an employment agreement of some sort, you want to ensure that you're taking steps that are consistent with that agreement. If you have a unionized workplace, obviously you need to make sure that any employment actions that you take are consistent with a collective bargaining agreement that may be in place. And of course, this is the big question that employers are going to have to answer in this type of situation, is whether or not you fully explored any other possible alternatives by going through the interactive process to determine if there are reasonable accommodations that don't provide an undue hardship to the organization. So telework is always a great option, allowing employees to work remotely for whatever period of time it may take for the rest of your employee population to obtain vaccines if they want them. And if that's not possible, it may be that employers are able to provide employees with a period of leave that would work as an accommodation until you reach a point where the rest of your employees have been vaccinated in a high enough level that the risk is significantly reduced. But at the end of the day, whenever you're making these types of determinations, it's really important that you go through the process, that you engage with the employee, that you fully explore any other alternatives that may be available, and make sure that you've documented all of those discussions and making sure that you really have a strong business-related reason that you can articulate as to why providing an accommodation simply wouldn't be feasible in this particular circumstance. So in addition to having to go through the interactive process and discuss accommodations with respect to employees who can't obtain the vaccine for disability-related reasons, Title VII also imposes an affirmative obligation on employers to accommodate employees who decline the vaccine for religious reasons. And this is a topic that's gotten a fair bit of attention over the past few months as people have learned more and more about the process that was used to develop and research these vaccines. There are certain considerations that may be objectionable to employees on the basis of their religious beliefs. In particular, the methods that were used to develop some of the vaccines, there are organized religions who've issued statements and guidance about how their practitioners should approach obtaining those vaccines. And so there could be circumstances where employees are entitled to an accommodation if they feel like they are unable to obtain a COVID-19 vaccine. So like with the ADA, the main question that employers have to answer is whether or not there is an accommodation for an employee's sincerely held religious beliefs, practices, or observances, unless providing that accommodation would result in an undue hardship. And here in the Title VII religious context, an undue hardship means that there has to be some sort of a burden on the organization that's more than a de minimis cost or other type of burden. So one aspect of the accommodation process with respect to religious objections that's a little bit more complicated than with a disability is what constitutes a sincerely held religious belief, practice, or observance. Well, under Title VII, that phrase is interpreted pretty broadly, and it includes not just beliefs that are the result of an employee's membership in some type of an organized religion, but they can also include pretty idiosyncratic beliefs that may not necessarily align with belief systems and traditions that employers are familiar with. And so in guidance that the EEOC issued on Title VII, they've said that a religious practice or belief is defined as moral or ethical beliefs as to what is right and wrong, which are sincerely held. And the fact that no religious group espouses such beliefs, or the fact that the religious group to which the individual professes to belong may not accept such beliefs, will not determine whether the belief is a religious belief of the employee or prospective employee. So what that means is that the types of beliefs that could be considered protected under Title VII and that could obligate an employer to provide an accommodation could be very, very broad. And they may not be immediately recognizable to an employer, but that doesn't change the fact that there still may be an obligation to provide an accommodation in those contexts. And so given the difficulties in determining, what constitutes a religious belief as opposed to some other type of strongly held view of an employee that's not entitled to protection, given how hard it can be to distinguish between those two things, the EEOC guidance states that employers should generally presume that if an employee approaches them and says they have some type of religious belief or practice that prohibits them from getting the vaccine, the employer should generally take their word for it, unless there is some type of an objective basis to question whether or not that employee's assertion of a religious belief is sincerely held. So, what constitutes an objective basis to question an assertion like that? Again, it's pretty unclear, and it can be very difficult for employers to feel comfortable that they have some type of a reason to question what the employee is telling them. And so the circumstances in which there is some type of an objective basis to push back on an employee's request for a religious accommodation would likely be pretty limited. And the only kind of example that I can really think of is if all of a sudden an employee comes to you and says, I'm unable to obtain this vaccine because of my, my Catholicism, when previously you had actual knowledge that they were a member of a different faith tradition, that could be a circumstance where an employer would be entitled to ask for additional information from the employee to substantiate the basis for their accommodation request. And so the types of information that an employer can ask for to validate the employee's request could include, written materials describing their religious belief or practice. You could ask for, some type of a statement from a faith leader, or, other types of documentary evidence. But in most cases, the employee's own firsthand experience and explanation of their religious belief is going to be sufficient to put the employer on notice that they have to provide some type of an accommodation. The EEOC's guidance went through a pretty lengthy explanation of the factors and considerations that employers need to consider when they're evaluating disability accommodations or religious accommodations, and sort of pre-assumes that the employer has the ability to impose a mandatory vaccination program. But there is one major ambiguity in the EEOC's guidance and other regulations issued by the FDA that call into question somewhat whether a mandatory vaccination program actually is permissible. And it has to do with the language that you see up here on the screen right now relating to the process by which these COVID-19 vaccines were approved by the FDA. So as many of you know, the Pfizer, Moderna, and Johnson & Johnson vaccines were not approved through the full traditional FDA approval process. They were simply granted an emergency use authorization, which is a shortened process and kind of a preliminary step before the vaccines obtain full authorization from the FDA. And so for as long as these vaccines are available to the public under an EUA and not a full approval, there are some limitations and obligations as to disclosures that have to be made to employees who are obtaining the vaccine. And so here it says the FDA has an obligation to ensure that recipients of the vaccine authorized under an EUA are informed of the EUA authorization, of the risks and the benefits of obtaining the vaccine, the extent to which there are benefits and risks that are unknown at this time, alternatives to the product, and most importantly, that employees or that individuals have the option to accept or refuse the vaccine. And this information is typically conveyed in some type of a disclosure form or fact sheet that's given to the individual at the time of the vaccine administration. So a question arises as to whether or not this language here, that individuals have the option to accept or refuse the vaccine, implies in the employment context. And there's actually, about a month ago, a case that was filed in court in New Mexico where an employee at a detention facility who was subject to a mandatory vaccination requirement by the employer, the case was filed and the employee was terminated because the employee refused to obtain the vaccine. And so he filed a suit in court alleging a wrongful discharge claim, saying that requiring him to get the vaccine fell afoul of this FDA language and regulations that are intended to allow employee or individuals the option to refuse a vaccine that was issued under an emergency use authorization. Now, this case is very new. I don't even believe that the complaint has been responded to, so we don't know yet how that's going to play out. And there are other questions as to whether or not it's relevant that the employee who filed the claim was an employee of a governmental entity and the extent to which his legal theories would be applicable to employees in the private sector context. So that's just something to keep in the back of your mind. Generally speaking, the consensus is that, at least for the length of the public emergency that's been declared with respect to the COVID-19 pandemic, the guidance that's being issued by agencies very strongly indicates that private sector employers would be able to mandate that employees get the vaccine, subject to the caveats that we just discussed. But if at any point the public emergency comes to an end and these vaccines have not yet obtained full authorization from the FDA, that might change. So just something to keep in the back of your mind and something to track as that case moves forward and we see whether or not there are any other cases that are similar that end up getting filed as well. So in addition to considering whether or not there are any disability or religious-based accommodations that employers are obligated to provide to employees, there are a few other kind of more logistical considerations that employers need to consider if they are imposing any kind of a mandatory vaccine program or even a voluntary vaccine program. So the first one we want to talk through is what employers need to know if they are actually administering COVID-19 vaccines to employees, whether directly or through a contract with some type of external third-party provider. Does that constitute a medical examination for purposes of the ADA? And as we talked about at the beginning, pre-pandemic, there were certain limitations on when employers should require medical examinations of employees or prospective employees. So the EEOC's guidance that they issued back in December states that no, with respect to COVID-19, the process of actually providing the vaccine to employees, either directly or through a third party, does not constitute a medical examination for purposes of the ADA. But that just implies the actual provision of the vaccine. If any of you have gotten vaccinated, you know that there are a list of screening questions that you have to go through to make sure that you don't have any type of a condition that would be contraindicated with the vaccine. And those types of questions could constitute a medical examination and may implicate the ADA provision relating to disability-related inquiries, in which case they're only allowed if the employer can show that the questions are job-related and consistent with business necessity. So that means the implications of that are that those questions are allowed only if excusing them, the employee from responding to them, would pose a direct threat to the health or safety of themselves or others. Meaning that, if the employee declines to answer those pre-screening vaccination questions, that means they'd be unable to obtain the vaccine. So you'd have to go through the same analysis that we just discussed about whether there are any alternatives that would eliminate the existence of a direct threat. Now, the context in which this is relevant is really only applicable if the vaccine is being mandated by the employer. And also if the employer is providing the vaccine in either directly or through some type of a close affiliate. It's not implicated in the context where, for example, an employer is referring employees to some other unrelated third party, like, CVS or Walgreens, if they have some type of a partnership. In that context, there wouldn't be any concerns. But if, for example, a healthcare employer is providing the vaccine and administering it themselves, these are considerations that they would have to keep in mind. So another thing that's important for employers to consider is if they're requiring employees to obtain the vaccine, what can they ask for as proof to confirm that the employee has actually obtained the vaccine? Are they able to ask the employees to submit some type of documentation to show that they had actually been vaccinated? And so the EEOC has said, yes, that is generally permissible. And asking for that type of confirmation would not constitute a disability-related inquiry under the ADA. But there are some complications that could arise. So for example, if an employer has an employee who wants to return to work in the actual workplace, who's been working remotely, and they ask the employee, have you been vaccinated? And the employee says no. If the employer asks any follow-up questions as to why they have not gotten the vaccine, those questions may get into an area that elicits information relating to a disability. If, for example, the reason the employee hasn't gotten the vaccine is related to some type of a medical condition that's contraindicated with respect to the vaccine. So if an employer has an employee in that situation and they want to ask follow-up questions as to why they haven't obtained the vaccine, the employer has to make sure that those questions are job related and consistent with business necessity, meaning that the employer has to have determined that it's necessary for the employee to obtain the vaccine, and the reasons why they haven't would have to be related to an assessment of whether or not any type of an accommodation is appropriate. But generally speaking, when an employer is asking employees to provide proof of vaccination, they should be sure to instruct employees not to provide any type of medical information along with that documentation. So anyone who's been vaccinated knows that you get a little card from the provider that gave you the vaccine. It confirms the date that you got the vaccine. It confirms the dose. It gives you information about follow-up appointments. And generally speaking, that would be adequate proof of an employee having obtained the vaccine. That wouldn't also bring with it any information of a medical nature that the employer would not be obligated to ask for. Next slide, please.
Alexandra,
Yeah.
when it comes to, asking for some of the basic information, maybe about the employees that choose not to be vaccinated, and employers are very careful to ask follow-up questions that don't lead to any disability-related answers, but they do reveal other answers that may not agree with the employer, such as political belief, affiliation. Do you have any tips for how that can be handled?
Yeah, so, if those types of questions reveal, as you mentioned, for example, political preferences that are resulting in the employee not wanting to get the vaccine, that information wouldn't necessarily be protected in any way unless you're in a jurisdiction that includes political affiliation as a protected characteristic. And I will note that DC is one of the few jurisdictions where that's the case. You just have to be really careful that ultimately, if you're making decisions about excluding an employee from the workplace who may not get a vaccine, that you're making those decisions purely based on business necessity. So, if you have a situation like that, it's particularly important that you go through the process of making sure you fully examined whether there are any alternatives that would allow the employee to continue working in a way that would not impose any threat to other employees in the workplace.
Fantastic, thank you.
Okay, another important consideration is, what do you do if you want to impose some type of a mandatory vaccination program, but you have a unionized workplace and there's a collective bargaining representative who represents some of your employees? Would a mandatory vaccine be considered a term or condition of employment that would be impose an obligation on the employer to bargain with the union? Very well could be the case. And so in those circumstances, you want to be very careful that you review the terms of your collective bargaining agreement to make sure that you're not running afoul of any provisions that may be in there that obligate you to engage in bargaining with the union. For example, you want to look and see if your agreement has what's called a management rights clause that reserves the ability to the employer to make certain decisions about policies and procedures that are in effect in the workplace. But also, in addition to the pure legality of it, you also want to make decisions that will maintain or won't impair in any way your relationship with the union. So if you are considering imposing some type of a mandatory requirement, it may be best to involve the union in some way from the get-go. So we'll just move through these last slides rather quickly so there's still some time for questions, but there are a few jurisdictions that have imposed some type of requirement to provide paid leave to employees for vaccinated purposes or vaccine purposes. New York is one of those. Employers who are covered are required to provide up to 4 hours of leave per injection, and that leave can't be charged against existing PTO balances or sick leave entitlements. It's a standalone obligation. And there's a prohibition on retaliating against employees who make use of or request that leave. California is another jurisdiction that's passed a similar requirement. And Illinois hasn't issued a law, but has issued guidance encouraging employers to provide paid leave or other compensation to employees who are getting the vaccine. So now we get to the big question, which is, even if you are legally allowed to mandate the vaccine, should you mandate the vaccine? And there are a lot of employee relations considerations to think about here because, as we've seen, there are certain segments of the population where vaccine hesitancy is pretty high. And so if you are imposing a mandatory requirement, it could result in some difficult conversations that you have to have with employees, and also could result in some difficult decisions you have to make if you have an employee who is reluctant to getting the vaccine. And employees, we've seen from some polling that's been done on the topic, who are hesitant to get the vaccine do so for a variety of different reasons. And a lot of times they're very sympathetic reasons and ones that a lot of people can easily understand. These vaccines were developed through a rapid process that worked more quickly than it typically does. And there are people who have concerns about potential side effects and are reluctant to get vaccines at this point, who may be, very diligent and well-meaning employees and individuals, but who do have some natural concerns. And so there are a bunch of pros and cons to consider. Morale is a big reason. What is the impact on employees who are reluctant to get the vaccine, who are subject to a mandatory requirement? What's the impact on employees who would like there to be a mandatory vaccine requirement, but the employer is reluctant to impose one? Employers should also consider any possible ramifications that could happen from an employee who has an adverse reaction to the vaccine. If it's mandated, it very well could be covered by workers' comp insurance. And on the flip side, what considerations are there for employers to consider about liability if someone else contracts COVID-19 in the workplace from an employee who's not vaccinated? So these are some of the common questions that we get along those lines. And one of the ones that come up pretty frequently is employers will say, so we have essentially two factions in our workplace. We have some employees who are extremely reluctant to get the vaccine and would be extremely uncomfortable with any type of a mandatory requirement from their employer. But on the other side, we have employees who are generally very concerned about safety in the workplace, and they don't feel comfortable coming into a workplace where they know there are employees who haven't been vaccinated. What do we do? And that's a tricky subject to navigate, but even if the employer is unwilling or unable to impose a mandatory vaccine requirement, there are still ways that employers can communicate to employees and message to them all of the steps that they're taking and should continue to take to ensure that their workplace is safe. Social distancing, mask requirements, and also, if it's possible, if you have an employee who's uncomfortable coming into the workplace knowing that there may be coworkers who are unvaccinated, exploring alternatives like allowing them to continue to work remotely, or maybe moving their workplace so that it's more isolated than where they would normally sit in the office. And so along those lines, we've seen questions come up where an employee may want to know, am I coming to work and am I going to be exposed to other employees who haven't been vaccinated? And if so, who are they? Because I want to avoid them. Is the employer allowed to answer those types of questions? And the answer to that is no. That type of information, if the employer has access to it, would be considered confidential medical information that has to be kept closely and not shared with other employees. So in those types of situations, again, one of the most effective things to do is to work with the employee who's expressed the concern and find out if there are any alternatives to explore that would make them feel more comfortable without disclosing any confidential medical information. And that same analysis applies if it's a customer who comes in and wants to know about employees who've been vaccinated or haven't been vaccinated, and whether or not they're interacting with someone who has not received a vaccine. The same considerations apply. And similarly, with applicants, employers are allowed to ask if they've been vaccinated, but only typically after a conditional offer of employment has been made. So again, it's information that the employer can access if they want to, but if they're making a decision to exclude the applicant because they haven't been vaccinated, you still want to go through the same analysis that you would if it were an employee. And then the last question, what should an employer do if the employee refuses to get vaccinated, but the employer doesn't want to fire them? A lot of times there'll be situations where the employer is able to work with employees and figure out alternatives. In the office context, as we've discovered throughout the pandemic, a lot of times employees can work very efficiently remotely. And so you always want to go through that process, particularly if you have an employee who's been with the organization for a long time, who's a valued member of the team. You always want to see if you can find ways to make everyone comfortable. And so all of these questions kind of get to the topic of what is the impact of a vaccination program on different classes of employees? Can we require vaccines for some employees but not others? Yes, so long as you have some type of a business-related justification for doing so. Same thing if you have employees in different jurisdictions. At the end of the day, you just want to make sure that you're administering your vaccine program in a way that's as consistent as possible, avoiding any type of a disparate impact on certain classes of employees based on a protected characteristic, and making sure that when you're in the process of going through whether or not an accommodation should be provided or not, you're making those decisions in some way that's kind of centralized so that you can ensure a level of consistency across individualized decisions throughout the workplace. And then finally, for many employers, it may be that a mandatory vaccine program isn't the way to go, but instead they want to do everything they can to encourage employees to get vaccines, as many who possibly can. Employers are considering incentive programs. Maybe you offer some type of a gift card. Maybe you provide some type of paid leave as an incentive for employees to go get the vaccine. In a lot of ways, this can be a very solid middle ground to address concerns of employees who want to make sure they're in a workplace that's safe, but also avoiding the compliance challenges and potential liability that could come with a mandatory vaccine program. Next slide. So, as we talked about, best practices. Whatever you do, it's important to develop a plan. Make sure that the people who are going to be administering it are trained, and that there is some way to ensure that decisions are being made consistently across the organization. And there, having your plan administered by human resources professionals and even legal counsel can be a great way to ensure that you have people with the expertise administering the program. And finally, whatever information that you get related to vaccines from employees, a lot of it will contain confidential medical information. So you want to make sure that that information is being stored separately from personnel files, and also that it's being kept closely held and access is limited to only those people with a business-related reason to know. All right, well, that's it. Unfortunately, we didn't leave many time for questions, but perhaps we have a minute for one or two if there are any that have come up in the chat.
Yeah, one that just came in regards to employers that decide to use incentive programs for vaccinated employees, would the employer also need to provide the same incentive to those that are unable to be vaccinated due to religious or health-related reasons?
Yes. So in that context, if you have employees who've been granted accommodations either under the ADA or Title VII, you would have to provide some type of comparable incentive. It doesn't have to be the same thing. One thing that we've seen is that employers have been offering, access to general safety courses that explain ways to continue staying safe in the workplace, even if if the employee has not been vaccinated. So generally speaking, yes, those are considerations that you would certainly want to take into account with respect to employees who've been offered an accommodation for some type of a protected reason.
Okay. And one last question. In the workplace, especially once we're back in person, employees may ask one another about vaccination status. While the employer can't share any particular employee's vaccination status, is it okay for one employee to share information about somebody else, or are there employment policies that should be put in place to manage that?
So in many situations, it depends on the role of the employee. So for example, if an employee voluntarily shares something about their vaccination status to a member of the HR team, for example, that's a situation where you would want to hold that HR person to the same standards of confidentiality that you otherwise would. If you have coworkers who are generally just voluntarily discussing their vaccination status with each other, That's not, necessarily a violation of any policies that you likely have in place. But if that information does make its way back to members of management, you want to make sure that they're not making any employment-related decisions on the basis of having that information. And if you have an employee, for example, who's been told by a coworker that they were or weren't vaccinated, and that employee shares that information with others against that employee's wishes, you very well may have a code of conduct or disciplinary policies in your handbook or that you've otherwise implemented in your workplace that would give you the discretion to decide whether or not disciplinary action is appropriate in those circumstances.
Fantastic. Thank you so much, Alex. And also a huge thank you to our listeners and to Nick from the SBA. We'll be sending out a survey to participants, so please share your thoughts on this webinar, as well as topics that you're interested in for the future. And along with that, you will get access to today's recording. And remember that if you'd like to speak one-on-one with an attorney about your organization's legal questions, view our upcoming events and our online resource library, you can visit us online at lawhelp.org/DC/CED. And once again, thank you so much to Alexandra Romero from Arent Fox for taking time out of her packed schedule to present on this important and incredibly timely topic today. And to Nick and his team at the SBA for finding time to share information on available resources for organizations, including the Paycheck Protection Program. Thank you all.